You have the right to an attorney. If you cannot afford one will be provided for you. Almost everyone knows that line. But there was a time not so long ago when it simply wasn't true. If you were poor and accused of a crime, you could be marched into a courtroom with no lawyer at all and convicted. The reason that change comes down to one man sitting in a Florida prison cell with no money, no law degree, and a pencil. He didn't just lose his case, he decided to fight it, all the way to the Supreme Court of the United States. This is the story of Gideon versus Wainwright, the case that decided whether every American, no matter how poor, has the right to a lawyer. It begins not in a marble courtroom, but with a break-in at a pool hall. One note before we start. This is legal history and education, not legal advice. In 1961, in Panama City, Florida, someone broke into the Bay Harbor pool room. A window was smashed. Some coins, a little beer and wine were taken. The police arrested a local drifter named Clarence Earl Gideon. He was a thin, weathered man in his 50s who had spent much of his life in and out of poverty and trouble. He said he was innocent, and he was charged with a felony. To understand why this case happened at all, it helps to understand the man. Clarence Gideon was no hardened criminal and no crusader. He was a poor, often unlucky drifter who had passed through gambling halls and odd jobs, in and out of jail for small offenses, for most of his life. He had little money and even less power, but he carried one stubborn conviction, that the system had treated him unfairly, and that the Constitution he had heard so much about was supposed to mean something, even for a man like him. That stubbornness, more than any legal skill, was about to change American law. When Gideon came to trial, he stood up and made a simple request. He could not afford a lawyer, so he asked the court to appoint one for him. The judge refused. Under Florida law at the time, a free lawyer was provided only when a man's life was on the line. So Gideon, with no training and no legal knowledge, was forced to defend himself. He questioned witnesses as best he could. The jury convicted him. He was sentenced to 5 years in state prison. Most men would have simply served the time. Gideon did something else. In the prison library, bent over a handful of law books, he taught himself just enough to believe the court had violated his rights. And then, in careful pencil on lined prison paper, he wrote out a petition addressed to the Supreme Court of the United States. It was exactly the kind of long-shot plea the court receives by the thousands, and almost always turns away. This one, it did not turn away. To understand what Gideon was claiming, we have to look at the Sixth Amendment to the Constitution. It promises that, in all criminal prosecutions, the accused shall have the assistance of counsel for his defense, a lawyer in plain terms. But for most of American history, there was a catch. That promise was understood to bind the federal government, and not necessarily the states, where the overwhelming majority of criminal trials actually take place. In fact, the Supreme Court had already faced this very question 20 years earlier in a case called Betts versus Brady. There, the court had ruled that the states did not always have to give a poor defendant a lawyer. One was required only in special circumstances, something that made a fair trial impossible without it. In practice, that left a poor man's fate to the discretion of each local judge. Gideon was, in effect, asking the court to admit that Betts had been wrong. The justices agreed to hear his case, and because the questions were so serious, the court did something telling. It appointed a lawyer to argue for Gideon, a respected Washington attorney named Abe Fortas, who would one day sit on the Supreme Court himself. The man who had been denied a lawyer at his trial would now have one of the finest in the country arguing his cause before the highest court in the land. The argument on Gideon's side cut to something basic. A criminal trial is not a fair fight between equals. On one side stands the government, with trained prosecutors, police, and the full machinery of the law. On the other can stand a single, frightened, untrained person. Without a lawyer, the argument went, a poor defendant cannot truly use the protections the Constitution promises him. The right to a fair trial written on paper becomes meaningless in the room. Florida pushed back. Requiring every state to provide lawyers for every poor defendant would be an enormous burden. In money, in attorneys, and in the reopening of countless old convictions where none had been appointed. And it meant overruling Betts, a precedent the court had stood by for 2 decades. Tradition and cost, the state argued, weighed heavily against such a sweeping new rule. On March 18, 1963, the court gave its answer, and it was unanimous. By a vote of 9-0, it sided with Clarence Gideon. The court held that the right to a lawyer is so fundamental to a fair trial that no state may deny it. If you are accused of a serious crime and cannot afford counsel, the government must provide one for you. Betts versus Brady was overruled. The opinion was written by Justice Hugo Black, who, by a quiet turn of history, had dissented in the Betts case 20 years earlier, and now at last saw his view become the law of the land. Anyone too poor to hire a lawyer, he reasoned, cannot be assured a fair trial unless a lawyer is provided for them. Lawyers in criminal courts, Black wrote, are necessities, not luxuries. That single idea reshaped American courtrooms. The right to counsel was now binding on every state through the 14th Amendment's promise that no person may be deprived of liberty without due process of law. It also meant that thousands of people already sitting in prison, convicted without a lawyer, might now have grounds for a new trial. Among them was Gideon himself, because here is what winning at the Supreme Court actually got him: not freedom, a do-over. Gideon's conviction was thrown out, and Florida simply put him on trial again, for the very same break-in. But this time, the courtroom looked different. This time, Clarence Gideon had a lawyer at his side, and it changed everything. His court-appointed attorney did what Gideon never could have done alone: picked apart the witnesses, raised the doubts, and told his client's story the way it needed to be told. When it was over, the jury did not convict. Clarence Gideon, imprisoned for a crime he had always denied, was acquitted and walked free. The right he had won with a pencil had, in the end, freed the very man who fought for it. But the deeper legacy was never really about one pool hall in Florida. Gideon versus Wainwright built the system of public defenders that still stands beside people who cannot afford a lawyer today. And if part of that promise sounds familiar, you have the right to an attorney. If you cannot afford one, one will be appointed for you. That is no accident. Those words, read at arrests across America, carry Gideon's victory inside them. But Gideon's promise came with a hard truth that still echoes today. Winning the right to a lawyer is not the same as winning a good one. Across the country, public defenders now carry the weight of that 1963 decision, and many are stretched impossibly thin, juggling hundreds of cases at once, with minutes to give where a case might need hours. The principle Gideon won is settled. The struggle to make it real, to give every poor defendant not just any lawyer, but a fair chance, is a fight that continues in courtrooms right now. Gideon opened the door. Keeping it open has proven to be another matter entirely. That is the quiet power of this case. Gideon is about a simple, stubborn idea that justice you can only have if you can pay for it is not really justice at all. A trial where one side has a lawyer and the other does not is not a fair contest. It only looks like one. By forcing the state to even the odds, the court tried to make the Constitution's promise real for the people most likely to be crushed without it. So the next time you hear that someone has the right to an attorney, remember where it came from. Not a senator, not a president, but a poor man in a prison cell who refused to accept that the law belonged only to people who could afford it. One pencil, one petition, a unanimous court. If the cases that quietly shape the rules we all live under are the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching, and remember, this video is for education and history. It is not legal advice.